and welcome to the 2026 version of our webinar, Legacy Planning Made Easy. I am Jill Santiago, founder of JMS Law. We are a Rhode Island-based law firm focusing on estate planning. My goal is to create legacy planning for my clients that fits their needs and meets their goals and create lifelong relationships with clients. I created this program to educate potential clients about estate planning basics, a primer of sorts for a full estate planning consultation free of charge. One disclaimer before we begin, this presentation is informational only and you should not take it as legal advice, nor does it create an attorney-client relationship. All right, now let's get started. Basically, there are three ways to die. The first way is intestate, which means you have no will. You're just relying on state law to dictate how your assets will be passed on. It works great for some people, like those who have no assets or who just don't care who gets their assets or who's in charge of their estate, or people who have no worries about avoiding unnecessary fees and taxes. If this is your plan, no plan at all, your assets may not go to who you would choose, and the person in charge of distributing your assets will be determined by a probate court judge. This may not be a person you would have chosen. The second way is testate, which means that you created a will before you died. A will simply dictates who will receive your assets when you die and who will be in charge of distributing the assets. This gives you more control, but it only operates after you die. Also, creating a valid will does not avoid probate. If you have assets that need to be titled to your heirs or beneficiaries, probate is necessary. Third, you can create a living trust. A trust is created by a declaration or a document that states the terms of your trust. You are the creator. You transfer your assets into the trust and control the assets during your lifetime. You name a successor person to control the assets in case you are incapacitated during life or when you're no longer living. A living trust provides greater control than a will, is effective during your lifetime as well as after death, and completely avoids probate, and therefore is completely private. We'll discuss the living trust at length in a little bit. But first, let's revisit the first way to die, intestate. Here in Rhode Island, there's an order of persons to whom your assets will pass if you die intestate. Your surviving spouse is entitled to life estate in your real property, plus a share of your other assets. Your children are your next of kin. If you have no living children, your estate will pass to your living parents. If no living parents, then it will go to your grandparents, then your siblings, your nieces and nephews, aunts and uncles, and finally, cousins. This can create a mess in a whole lot of scenarios, such as married persons who do not own properly jointly, unmarried persons with partners, people with no children or estranged children, and so on. Let's move on to the second way to die, testate. Most people have heard of the will, but what exactly is this document? Simply put, it's a document you create that transfers your assets to another when you die. It takes effect at the time of your death and has no effect during your lifetime. Most of the time, a will must go through probate in order to pass the assets on to someone else. The will dictates who is in charge and who gets your stuff. There are many advantages to having a will in addition to having your assets distributed in accordance with your wishes. While it doesn't avoid probate, it does make probate easier. Wills are typically less expensive than other estate planning tools, such as trusts. In Rhode Island, there's a 6-month limit on creditor claims filed in probate court. After the 6 months, creditors lose the right to file any claims against the estate. However, wills are not always the best option. They must go through probate, and a will only addresses the situation at the time of your death, not unpredictable things that can happen during your lifetime, such as an illness or an accident that leaves you incapacitated and unable to handle your affairs. Further, a will still leaves the estate open to creditors, and additional steps are required when assets are located in different states or countries. This is why creating a revocable living trust is a better option in many cases. Other complications may arise out of a will, such as the will being invalid. This may happen when a will is not properly executed or witnessed, or a will may be challenged by someone as invalid. The challenges may involve determining who will be a personal representative if multiple people have petitioned the probate court. Family conflicts, such as disinherited family members, contesting the will can lead to complicated and expensive litigation. Also, complicated estates, such as those with a lot of assets in multiple states, may require multiple probate cases to be opened. And of course, probate costs time and money. In Rhode Island, there's a minimum of 6 months that a probate case must be left open. It can involve a lot of fees, including legal fees. It's a better way. Let's move on to way to die number 3, creating a living trust. The revocable living trust. What is it? To understand the revocable living trust, think of it as a treasure chest that the attorney creates for you. In it, we transfer your assets. To make it simple, a trust is just another way for you to hold title to the assets you already own. In a trust, we need 3 players. First, the trustor or the grantor, who is the person giving the assets to the trust, which is you. Second, the trustee, or the person in charge of the trust assets, which may also be you. And finally, the beneficiary, or the person for whom the trust assets are to benefit. This may also be you. The trust document we create will provide specific rules for how the trust property is to be managed both during your lifetime and after death. Trust is a complicated but very flexible legal entity created to hold your property during your lifetime and beyond. The document will contain provisions for managing assets during your lifetime, during your incapacity, and after your death. A very important aspect of forming a trust is to fund it. All this means is that you must transfer the assets into the trust in order for it to take effect. For example, Mr. Monty Python created his revocable living trust on the 31st of January, 2024. On that day, or shortly thereafter, he executes a deed for his real property from himself individually to himself as trustee of his trust, giving the home to his trust. He also signs paperwork with his financial advisor to transfer his investment accounts into the trust. Now his trust is funded. In addition to the trust document, it is prudent for the estate plan to have a few other documents. A financial power of attorney, which appoints someone to act on your behalf in financial matters if you're incapacitated. This, in addition to the trust, will protect you against guardianship proceedings. A pour-over will, which pours any assets which remain in your name at the time of your death into your trust. A healthcare power of attorney, naming the persons who can make healthcare decisions for you if you cannot make them for yourself. And a living will, which states your end of life wishes. The revocable living trust works differently at different times. While you're living and fully capacitated, it holds your assets in one box. If you become incapacitated, your successor trustee takes over and manages the assets for your benefit and the benefit of your beneficiaries. There is no need to involve a probate court. For death, the successor trustee takes over and pays any taxes due, pays your legitimate creditors, and distributes the balance of the trust assets in accordance with the trust terms. Now, let's take a closer look at how it performs at each different phase. First, we'll look at the trust and see how it works while the spouses are still alive. Next, we'll see how it operates after one spouse passes away. And finally, we'll look at the trust and see how it operates after both spouses pass away. By the way, if you're single, divorced, or widowed, these concepts still apply, but your trust will have just two periods, the first and the third. Let's discuss the joint trust for a married couple. In the beginning, both spouses are co-trustees of the trust, which holds assets such as cash, life insurance, retirement accounts, and real estate. When the first spouse dies, that spouse's share passes to a family trust. Spouse number two has the right to access the principal and income of the family trust for the duration of spouse two's life for maintenance and support. The family trust is the share being preserved for future beneficiaries. So the surviving spouse will not have the right to give that share away to someone else, like a new spouse. At the death of spouse two, the trust funds are distributed in equal shares to their living children, here C and D. Revocable living trust can be utilized in the simplest of plans, which includes where all the assets will be transferred to your children at the death of you and your spouse. But even the simplest trust should contain language to cover all sorts of unknowns, such as your disability or the disability of a beneficiary. The trust should also provide definitions for making special distributions, such as for education or for housing. For those with more complicated estates or family dynamics, a living trust can be drafted to provide divorce protection for beneficiaries, meaning if one spouse dies and the survivor remarries, the trust beneficiaries are protected from losing their inheritance to that second spouse or that person's family. Provisions can also be created to help avoid or minimize estate taxes. An irrevocable trust can be created to protect your assets against nursing home costs. About what the revocable living trust doesn't do. First, it will not provide protection from your creditors during your lifetime. And second, it does not provide protection from Medicaid eligibility or protection from Medicaid liens for nursing home or long-term care costs. These protections require additional, more advanced planning. In probate, the living trust provides for growth of assets during your lifetime. A trust is harder to challenge than a will because it's private and it's only shared with the beneficiaries. Also, rather than making a challenge in the probate court, the superior court has jurisdiction over issues concerning trusts. This is a much more daunting process, and trust litigation is very expensive. Your trust should include language to discourage beneficiaries from making these types of challenges. While there are no real disadvantages to using a trust over a will, the biggest downside of creating a trust is that it's more expensive to prepare than a will. But it may be less expensive in the long run by saving thousands of dollars associated with probate administration or tens of thousands of dollars in long term care costs. Also, you have to place the assets in the trust in order for it to work. This is the biggest problem I run into when trusts are created using online document production sites like LegalZoom or Trust and Will. Because you're not getting personalized legal advice from these sites, the funding stage of the trust creation is often ignored. Estate planning is a complicated and nuanced legal practice. There are many ways to create an estate plan. Do it yourself online plans where artificial intelligence creates a generic set of documents for you without providing any explanation, answering your specific questions, or recognizing any potential issues that you may not have considered. Sure, these are cheap and they're fast, like fast food. It exists, it's edible, but in the long run, it's probably not good for you. There are many lawyers out there who will draft cheap wills or trusts without any specific expertise in estate planning. What you get is a set of documents, then they send you on your way without any follow up or trust funding. These plans could be cheap, but they could be rather expensive. I see all kinds of botched plans for which people paid a huge range of fees. One thing they all had in common is they failed, or they would have failed, to complete the client's wishes and goals. Then there's your best option, which is to go with an experienced estate planning attorney. Here at JMS Law, our journey together started here with this webinar. If you decide to move forward with a plan, you will go through a multi-step process to flesh out your issues and concerns and create a solid estate plan that actually works and continues to work for your lifetime and beyond. This webinar isn't live, so there's no real opportunity for a question and answer session, but I do encourage you to ask questions. You can schedule a 15-minute call on our website or email us directly. I'll be happy to answer your specific questions. I will, however, answer a few frequently asked questions here. One super common question is whether I need a trust or not. The answer will depend on your specific concerns and goals. There's no magic number that determines whether you have enough wealth to justify creating a trust. The types of assets you have, where they're located, and your family dynamics are all factored into that decision. Many people benefit from creating a trust, but many people can achieve their goals with a will plan. Another really common question is, how much does estate planning cost? Well, that is a good and valid question, which I must respond to with a question. Is the cost the most important aspect of creating your estate plan? If it is, this may not be the best fit for you. While I cannot provide an exact quote without having a full consultation, you should be prepared to spend $2,000 to $3,000 on will-based plans and $4,000 to $5,000 on revocable trust plans. Advanced plans, including Medicaid protection trusts, are going to be more expensive. What I can tell you for sure is that your plan will be billed as one flat fee. You will know exactly what the total cost is before you decide to move forward. All trust and will plans include financial and healthcare powers of attorney, a living will, and your HIPAA waivers. With trust plans, funding assistance is also included. You will not receive any unexpected bills, even if you call me with questions after your estate plan is complete. You'll also receive occasional notices and reminders, ensuring that as life changes, your plan still works for you. The cost of your estate plan is an investment that can save a lot in the future. Probate typically costs 1.5% to 5% or more of the value of your whole estate. For example, if you have an estate worth $500,000, you could expect probate fees to run from $7,500 at the low end to as much as $25,000. And another frequently asked question is, how do I fund my trust once it's created? Most people's largest asset is their real estate. JMS Law will take care of drafting and recording the proper deeds into your trust. We'll also walk you through the process of transferring your other assets to the trust. Your homework will be creating a list of those assets. And the last question is, where do I go from here? Well, are you ready to move forward? If you are, then your next step is to schedule a face-to-face meeting. You can do this at your convenience on our website, either in one of our offices or on Zoom. Once you book, you will be asked to complete and submit a pre-consultation form. And because you watched this webinar, you are entitled to receive this consultation for free, which would normally cost $450. If you're not ready to move forward, no problem. As I said before, feel free to reach out with any specific questions.